of time bar are of pivotal importance to practitioners and also to clients in any jurisdiction. The law of time bar, or prescription and limitation, as we call it in Scotland, is regulated by the Prescription and Limitation Scotland Act 1973, and this Act applies to all claims where the underlying obligation is governed by Scots law. A new Act has recently been introduced called the Prescription Scotland Act 2018, and it obtained royal assent on the 18th of December 2018. It will amend the 1973 Act, and I will be coming on to speak about some of the key changes later in this webinar. At the time of filming this webinar, the substantive provisions of the 2018 Act have not yet come into force, and transitional provisions have not yet been confirmed, so please do keep an eye on our website for updates.
Prescription has the effect of extinguishing a right or obligation completely after a period of time has passed. This is a matter of substantive Scots law, and it's applicable wherever litigated. Limitation, on the other hand, does not extinguish rights or obligations, but introduces a procedural bar on raising legal proceedings. Under the 1973 Act, standstill agreements are of no effect in Scotland. The only way to avoid the claim being lost through prescription or limitation is to effectively serve proceedings on the defender. Unlike in England, it's the date of service of the writ that stops the clock, not simply the date of lodging proceedings in court. There's a 20-year long stop for avoiding stale claims, and this starts when there is a concurrence of injury and damage, or injuria and damnum, to use the Latin we love so much.
So what are the prescriptive periods? The time periods vary depending on the type of claim you're dealing with. Claims to pay money or compensation in contract or in delict, i.e. tort, tend to be the most common claims encountered by clients. For these types of claims, the prescriptive period is 5 years from the date of breach of contract or from breach of duty, subject to rules as to when the clock starts ticking. Note it's 5 years in Scotland, not 6 years as is the case in England and Wales, and that can sometimes trip up claimants who are more used to dealing with the English rules and think they have more time than they actually do. We also do not have the same concept of primary and secondary limitation as you do in England and Wales. There are, however, some limited circumstances in which the clock may start at a later stage. The 5-year period I spoke about is frozen during any period during which the creditor was induced to refrain from making a relevant claim by reason of fraud on the part of the defendant or any person acting on their behalf, error induced by words or conduct of the defendant or any person acting on their behalf. This does not include any time after which the creditor could, with reasonable diligence, have discovered the fraud or error. For certain claims relating to property, the prescriptive period is much longer, at 20 years, and there are different periods for claims in relation to defamation, harassment, product liability and personal injury.
The law of time bar has been a hot topic in Scotland since late 2014, following the decision in a Supreme Court case, the case of ICL Plastics. This case overturned around 30 years of what was believed to be settled law about when the clock starts to run. The Supreme Court held that the way in which the Scottish courts had for those 30 years interpreted the Act was wrong. The 5-year period starts on the date the claimant knows they have suffered loss, injury or damage, or the date on which with reasonable diligence they could have known they had suffered loss, injury or damage. There was no need for a claimant to be aware of the identity of the defender or that they had an actionable claim in law, as had previously been thought to be the case by the courts. This decision was regarded by many as being unfair and means that the prescriptive clock in Scotland can begin at a very early stage indeed, and possibly much earlier than would be the case in England and Wales on similar facts. Following on from the decision in ICL, there were various calls for reform of the law. It was considered that the decision was very harsh for claimants, especially since claims could potentially time bar in Scotland when a claimant didn't even know the identity of the defender.
The Scottish Law Commission were asked by the Scottish Government to consider the law in this area, and a new bill was introduced following a consultation exercise. The Prescription Scotland Act 2018 obtained royal assent on the 18th of December 2018 and brings into force a number of the Law Commission's key recommendations. The 2018 Act amends the 1973 Act, and so whilst there's a number of important changes, this is not a wholesale revision of the law in Scotland, and the majority of our rules on time bar remain unchanged. The first of the changes under the Act is the introduction of a new discoverability test. The second key change is the introduction to Scotland of standstill agreements, and Elaine's going to talk about that later. And the third change is a change to how our 20-year long stop period is calculated. Taking each of these in turn. The new discoverability test is a test which has been devised to seek to deal with ICL and addresses what were considered to be the harsh consequences on claimants as a result of the decision. The new test under the Act has 3 strands. The claimant must be aware, firstly, that loss, injury or damage has occurred. Secondly, that loss, injury or damage was caused by a person's act or omission. And thirdly, they must be aware of the identity of that person. It's important to bear in mind that this new test does not, however, reinstate the law as it was previously understood prior to ICL, but rather the test seeks to strike a balance between claimant and defendant. As is the case under the ICL decision, a claimant does not need to know that they have an actionable right in law.
The lack of standstill agreements in Scotland has long been criticised as hindering parties who are seeking to negotiate claims and leading to unnecessary cost for parties who require to raise protective proceedings in order to avoid the claim becoming time-barred. The new Act will allow parties to enter into standstill agreements. However, there are restrictions, and Scottish standstills are not going to be the same as or as flexible as parties might be used to in England and Wales. A standstill will operate to extend the 5-year prescriptive period. However, it will only be available when the prescriptive period has started to run, only one standstill agreement can be entered into, and the maximum duration of that standstill is 1 year. So you could not, for example, agree to a standstill of a year and then, if you didn't settle, agree to another standstill or extension. It's unclear how much these limited standstills will be utilised in practice once the Act comes into force, but their introduction is certainly to be welcomed.
One of the other changes coming in from the new Act is to our 20-year long stop period. Under the 1973 Act, the 20-year long stop period runs from the date on which an obligation becomes enforceable. As Elaine mentioned earlier, to start the 20-year clock running, there must be a concurrence of injury and damage, or injuria and damnum to use the Latin. Depending on the circumstances, the damnum part of that test, that is the loss, injury or damage, might be incurred many years after the wrongful act or omission took place. As a result, under the present law, it is possible for a long period to pass before the prescriptive period will start to run. This was seen to undermine one of the key aims of the rules on time bar, which is to prevent stale claims, as well as causing considerable practical issues for parties in pursuing or in defending claims. Under the 2018 Act, the 20-year long stop period starts on the date the act or omission took place. It will also not be possible to extend the long stop period by way of a standstill agreement. These changes were thought to better ensure that it is indeed a long stop, not only in name but also in effect, and were also considered to improve certainty for parties.